Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
Welcome to St. Louis on the Air. I'm Don Marsh. It's Legal Roundtable Day, and we'll be spending part of our time looking at the legal ramifications surrounding Missouri Governor Eric Greitens' admitted adulterous affair. There are potential criminal charges. We'll also discuss continued legal fallout from the shooting death of Michael Brown, and the lawsuit against the Rams because of their move to Los Angeles is moving forward. Joining me in studio are Bill Freivogel, professor of journalism at SIU in Carbondale. Mark Smith is Associate Vice Chancellor and Dean for Career Services at Washington University. And joining us once again is Peter Joy, the Henry Hitchcock Professor of Law at Washington University. Gentlemen, thanks for being with us. Happy New Year. Haven't seen you since the old year. Good you have you with us. Peter, I'll start with you. You were quoted in the Post-Dispatch story on the Greitens affair this morning. What do you think the chances of prosecution of Governor Greitens would be?
Well, based on what we know at this point, unless the woman that he had the affair with comes forward, there's a zero chance of prosecution. Because without her cooperation, based on what we have heard, there's a lot of speculation, but not a lot of hard facts.
Could the tapes that portions of which most of us have heard, could the tapes be considered probable cause in any sense of the words?
The tapes alone, I don't think so, because first of all, it's just hearsay, and for probable cause, you can use hearsay, but we don't know whether what she said actually happened. Without her verifying it in some way, even though a prosecutor, in theory, might say we have probable cause, they know they could never take the case to trial without her cooperation. So ethically, a prosecutor would be restrained in starting a prosecution when they don't have any viable theory to take it to trial.
Bill Freivogel, it seems like Kim Gardner, the circuit attorney's hands are tied then.
Well, yes. I mean, I guess she could subpoena the woman. That's not the best of. Joel Currier's story in the paper this morning sort of quoted a lawyer saying it was a little bit like a domestic abuse victim. You know, if the victim is not really wanting to cooperate, it's difficult. But I think that Kim Gardner could subpoena her in an attempt to get cooperation. I mean, if she cooperates, then it's an entirely different situation.
But she can't be compelled, or can she?
I guess she could be. She would have to appear. She could take the Fifth Amendment if she has some sort of, if there's some sort of criminal conduct that she thinks she could have been involved in. But I believe that she could be required to appear before a grand jury if there were one.
Mark, what's your take on all of this?
Well, I agree with what was said, and Greitens has come out and specifically denied. That there was the things that could get him in trouble. He's denied there was violence, there was blackmail. He's denied that he made any kind of payments to quiet her. The one thing he's kind of sidestepped, and we talked about this, is whether or not he took a photo. He seems to acknowledge that there was a photo, and so if he takes the photo without her acknowledge, that could be something. So I agree. Unless she agrees to cooperate, if she just doesn't want to cooperate, they're not going to go forward. And unless they discover something, that campaign funds were allocated to her and that's some kind of cover-up and they didn't report it, I don't see how it's going to keep going forward.
Peter, it would seem to me, and again, please correct me if I'm wrong, that there are only two potential charges anyway. One is blackmail, attempted blackmail, and the other is invasion of privacy through a photograph of a nude or partially nude woman. Is that correct?
Yeah. Those would be what we know. If she was bound and gagged and had not consented to it, that would also be assault. So that's, another potential charge that could be out there if he did this against her will. But again, without her cooperating, I guess I'd also like to add one thing about the comparison with, say, a domestic abuse case. sometimes those cases could go forward without the cooperation of the victim. But that typically involves a person calling up the police and then telling the police what happened in an excited state. That's an excited utterance, which is an exception to hearsay. And also the police then generally have photographs showing, the physical abuse that has taken place. But here we don't have excited utterance. We don't have any photograph. So I just don't see it going forward.
Scott Rosenblum, who's a well-known defense lawyer, told the Post-Dispatch that he thought one potential, if there were just in a hypothetical situation, that you could possibly have a case for extortion, if there was cooperation, obviously on the part of the woman, where someone demands silence with a threat of embarrassment, that could actually fit into the category of extortion. But again, that's just hypothetically speaking. But the governor's already admitted to things that are politically incredibly damaging. They tried to say this a long time ago, but it was only a couple of years ago. And as Mark said, he has not denied taking a picture of her blindfolded and tied up. Maybe he will deny that at some point, but he has very explicitly not denied that. Even in the interview he had with the Associated Press. So, politically, he was being groomed to be president. Mm-hmm. He had been the Fox News Sunday News Man of the Week twice last year. That's not in his future, and he's got a lot of Republicans who he had prior to this he had alienated, and they're not big friends. I noticed Mike Wolf was the former Supreme Court judge in Missouri. Said he pointed out that the House could impeach him without some of these problems of what's admissible in court possibly, but that he doesn't really see there being an appetite to do that.
We should point out, too, that consensual sex is not against the law. Right. It's these other things that would be difficult, if not impossible, to prove that would be a problem.
Immoral, but it's not illegal.
Yeah.
That's exactly right. And there's lots of things that are immoral that law doesn't punish, and that's just the way it is.
And the chances of impeachment, Mark, I would think would be remote to none because it's a Republican-controlled
And even though
assembly.
he seems to have antagonized a lot of the Republicans, I don't think they would go that far. Mm-hmm. So, I think barring some other thing that would come out, I see this, like Bill said, he's wounded. I think the chances for president are shot. I don't know if he can get reelected as governor if he wants. I wonder what will happen. He's got all this money that's coming into what is that group, Better Missouri, or his
dark money
group. Yeah. And
Dark
so
money,
one wonders if that will continue to keep coming in or if that's going to dry up.
Let's just look at what, Peter, I'll go back to you on this. Go back to the supposed FBI investigation. CNN has reported it. Other news outlets have reported that the FBI is investigating.
And didn't a Missouri senator say he had been interviewed by the FBI?
Someone did, yes. Greitens' lawyer is saying there has been no contact from the FBI. Does there have to be contact? Can't the FBI investigating without telling the person they're investigating that we are investigating?
Yeah, well, actually, most of the time the FBI doesn't contact someone that they believe may have committed some criminal conduct. But they will investigate potential leads that could bring them on to some evidence. Typically, a target wouldn't be contacted till after they really assembled a case against the person, and then at that point in time, the U.S. Attorney's Office would be involved. For all we know, the U.S. Attorney's Office could be involved if there is a FBI investigation that has gone on.
But, Bill, wouldn't that be happening under the same constraints that Kim Gardner is facing?
Well, yeah. I mean, they would still have the issue of how do they get this tape to be admissible, and it's hearsay, and they need somebody to verify that they said it and that the acts occurred. And yeah, they would have similar problems.
Their resources are extensive, needless to say, but really not so extensive as to be able to overcome these hurdles, I would think.
Right,
Mark.
right. Although, the lawyer for the ex-husband apparently has more tapes, and he's, I think, released some of them. So, I mean, I keep waiting to see if another shoe's going to drop. I mean, this was definitely a bombshell, but I don't think, like we've said, nothing that legally probably could be used in a criminal prosecution. But if there's all this other stuff out there, one wonders what else might happen.
There is also an awful lot of rumor out there. I mean,
Yeah.
we have to admit that we're hearing all sorts of things with regard to this case, most of which has been unproven, which brings me back to you, Bill, because this has been an issue since the story first broke, and that is, should it have been reported at all? We had the reporter who broke the story for KMOV on the other day, and she justified her actions, and quite well, most people thought. What do you think, as the journalist in our midst?
Well, I heard that interview that you had with her, and I, too, thought she justified herself well. I mean, I understand the sort of argument that, this is the woman's story, and it was the woman's story to tell, and her former husband is I don't know what his motives are, but it wasn't his story to tell. So I'm sympathetic to that argument. But on the other hand, I've also talked to the KMOV reporter, and as I understand it, she had talked to the woman extensively. I believe those were off-the-record conversations. I mean, one would have to assume that they wouldn't have gone forward with the story unless those conversations substantiated what was said on the tape. If they didn't substantiate what was on the tape, then the story they shouldn't have gone forward with the story. But if the off-the-record conversations did substantiate what she said on the tape, then I think that the reporter acted properly and carefully in moving ahead, getting a governor's comment. And once the governor had acknowledged on the record the affair, then they're in. Then I think I would definitely have published under those.
And a lot of people have attacked the ex-husband, saying, "Well, he brought this story forward because of bad motives." But Bill and I were talking about this last week. I mean, I think a lot of times the people who are leaking information, they're mad about something. They feel scorned or underappreciated, or I got screwed on this.
They have their own agenda.
Yeah, they got their own agenda, and that's
almost always the best sources have got next to
have a lot of anger. Right?
Deep throat. Mark Felt was mad at Nixon because Nixon had passed him over to be head of the FBI. Yeah.
I also think there's another angle on this, and it's you have a governor who runs on family values, who takes a very high moral stance. It reminds me of a long time ago with Gary Hart's presidency, where there had been rumors that he was having affairs, and he dared the press to follow him, and they did, and they found him on a boat having an affair. So I think there's a little bit of, don't live in a glass house and take the moral high ground when, in fact, you have your own flaws.
I don't know what it is amongst some of these people who have power and influence to think that they can get away with stuff. It just sooner or later tends to catch up.
Right. And I'm not saying that this is the case with him because I don't know the governor at all. But, yeah, these people who start thinking, their book, Bonfire of the Vanities, they talk about these people who think they're the master of the universe and the rules don't apply. And the rules always apply.
Yeah.
I mean,
I have to say that Gary Hart and Monkey Business looks like pretty tame stuff compared to, to this and to the reports in the news about the president, about the lawyer for the president paying money to a porn star a few weeks before the election to get her to remain quiet about an alleged sexual affair. So boy, oh boy, But Gary Hart's pretty tame stuff.
But, we have to take a break. He was not rehabilitated, really. But Mark Sanford was, the former governor of South Carolina, now in Congress after that problem. Elliot Spitzer is now making his way back into the mainstream. People like that who've gone through.
America's a forgiving place.
Bill Clinton We can't leave him out.
Bill Clinton, they keep talking about it, but he still keeps making a lot of money for his foundation and whatnot. Anyway, let's take that break. We'll come back, continue our conversation with our Legal Roundtable panelists, Bill Freivogel, Mark Smith, and Peter Joy. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. And welcome back as we continue our Legal Roundtable panel discussion with Bill Freivogel, Mark Smith, and Peter Joy. Anything you gentlemen wish to add with regard to the Greitens situation? In that case, I'll bring in a listener who raises an issue that we might want to discuss for a moment. Mark joins us from Potosi. Go ahead, Mark. You're on the air.
Thanks for taking my call. I'm curious whether or not there's any possibility of there being a recall election for against the governor. I never heard this really brought up in any discussions. And I have one more question. Could the husband of the wife, could he bring a lawsuit against the governor for alienation of affection? I'd like to hear what you guys say about that. Thank you.
Could there be a recall vote, and could the wife of this or the husband of this woman file a lawsuit of some sort? Any thoughts on this, gentlemen?
I don't think we have recall in Missouri.
I don't know. Yeah, I don't know.
It would depend on whether Missouri has recall. I don't. There have other states have recall. Like famously in California, the recall of Gray Davis. But I don't believe we have that. I think our option is impeachment, and that would start in the Missouri House.
And as far as the lawsuit for alienation of affections, I mean, that's not a very favored kind of cause of action anymore. And given who the lawyer is for the husband, if that was a viable option, I suspect that lawsuit would have already been filed.
One more call on this subject, then we're going to move on. Fred and Glendale, go ahead quickly, please.
Okay, Don, I was just wondering why the FBI was involved in Governor Greitens' indiscretion case. I thought the FBI only dealt with federal law. Is federal law involved in this, kind of a domestic situation?
Thank you, Fred.
So what occurred to me, Fred's exactly right, but it was. So I was thinking if campaign funds were used, that's why I mentioned that. If campaign funds were used inappropriately and not reported, well, then the FBI would be investigating for violations of federal election, or this is state law, but there would still be subject to federal election law. So maybe that's what's going on. But the FBI doesn't talk, so we don't know.
It's a good question, though.
Yeah, and if there's any kind of way in which a federal crime could have been violated, like using the wires, interstate communications to the woman, or if it were to involve something, using the wires to advance an extortion. So it's plausible, I think.
Yeah, and I agree with that.
Just to return to something, the previous, I don't know if it was Fred or the one before, this alienation of affection thing. The interesting thought there, and we're going to talk about the Ram suit later on, but
hopefully, if we ever get rid of this subject.
A lot of times when you sue somebody, you may not win with the lawsuit, but you get to go through a discovery process. And when you have a lawsuit, you get to then ask the other side, I want to see all the documents related to this. You can get to ask people questions under oath. That's what got Bill Clinton in trouble. Mm-hmm. He lied under oath. And lots of people don't want all their documents being produced. And so if I tend to agree with Peter, I think if they could have brought a suit, they would have done it just so they can engage in the discovery process. And I think with this Ram suit, that the Judge McGraw denied their motion to dismiss, so the NFL had put on hold all the discovery requests, saying, well, this case may not even go forward. So now it's going to go forward. So I think you're going to see the NFL maybe coming in and saying, well, is there any way we can settle this so we can save ourselves all a bunch of trouble? But maybe they don't want someone snooping through all their documents to see what kind of little hidden gems might be in there.
Well, as you indicated, and we can dispense with that now, the Ram suit is moving forward.
Yeah.
And the city and the county and other interested parties are licking their chops, I think.
Yeah.
There's a lot of money out there in the NFL. One other thing concerning the governor, and that is I'm sure you're familiar with the fact that he's being sued for using an app that erases phone messages and what have you. The suit alleges the use of automatic communication destroying software by elected officials and government employees is illegal and constitutes an ongoing conspiracy to violate the Missouri Sunshine Law and Missouri State and Local Records Law. That's a quote from the language from the suit. Any comment on that, or should we move along?
Oh, I think that's an important issue. I mean, the idea that the governor is using something that destroys his messages, I think is pretty outrageous. Whether it actually violates the Sunshine Law, it requires a couple of different legal issues. Does the governor by himself constitute a government body? He may. I know lawyers for the Missouri Press Association say that he does. Are communications on his personal cell phone, if they relate to government business, are those communications that would be then a government record by a government body? If one would think that they would be, and that would be something discoverable. I know that the Attorney General Josh Hawley has got people looking at this situation. And Hawley himself has made just last week he made an interesting proposal for strengthening the Sunshine Law, revisiting the Sunshine Law to strengthen it, and talked about signing a specific group of lawyers to defend the Sunshine Law, lawyers who don't otherwise defend state agencies, so they would be more independent. So all those are sort of interesting developments, but the governor shouldn't be using these Mission Impossible, destroy the message kind of.
Especially, Peter, one who ran on transparency years ago.
Right, exactly my thought.
Yeah.
It leaves one just wondering, what's he hiding?
Mm-hmm.
Of course. Well, in addition to the Sunshine Law, they're also saying there's this Missouri State and Local Records Law, which says you cannot destroy records. But as Bill said, the question then is, are these emails in your official capacity, or is it just personal? And the line's not going to be completely bright. But
and especially
both.
If they've been destroyed and there's no record of them, there's never any way of answering that question.
Of course, the governor has taken a page out of Donald Trump's book to say that the stories about this are just more of the liberal press. I think in this case it was the Kansas City Star that first disclosed it. More of the liberal press just trying to get him.
Yeah. Okay, let's move on to some other things. Dorian Wilson is the young man who was with Michael Brown, shot in August of 2014.
Yeah, Dorian Johnson. Right?
Yes. What did I say?
Wilson. But
Wilson is the police officer. Dorian Johnson. Thank you for correcting that. A federal appeals court will decide whether Johnson, can sue a city police officer and other city officials on the basis of the Fourth Amendment. That is the potential suit. What is the Fourth Amendment part of this? Okay,
well, the Fourth Amendment protects us from the government unlawfully seizing us, and also conducting searches in I mentioned seizure. And here the issue in Judge Fleisig in the district court decision about this struggled with it was, did Dorian Johnson feel that he was detained by Officer Wilson? And the key thing there was Wilson said, get on the sidewalk. He and Mr. Brown did not get on the sidewalk, and then the police officer backs up his car, almost hits them, showing that he's like coming to them. Would somebody feel like the police want me to stay here? I really am now being detained. And that's a close question. She said that it was sufficient enough to go forward to trial. There's a legal argument going both ways, and that's what the Court of Appeals will decide.
So there was a panel of the Court of Appeals that's also already ruled on this after Judge Fleisig, and a 2-to-1 panel said that there was enough evidence that he had been seized that he could claim this Fourth Amendment rights were violated, and that the case could go forward. The fact that the entire circuit en banc is has decided to hear the case, I think means that there's at least a substantial number of judges on the Eighth Circuit, which is a rather conservative circuit, who may not agree with that panel decision, so they may think that this did not amount to a seizure, and so therefore the case couldn't go forward. One thing that when you read the court decisions on this, at this point the judges have got to they take the claims of the person suing as being the facts.
Right.
We're going to assume the facts. And under those facts. Michael Brown was grabbed by Officer Wilson. Officer Wilson pulled his gun, shot him twice, and then shot him running away. Well, it sort of, and didn't ever resist arrest. Well, that is not what the investigation found. So, the judges here are taking it on this legal basis, legal fiction, really, of here's the facts according to the motion to dismiss, and so should the case go forward? If the case ends up going forward, they're going to have a lot of trouble winning.
We have another judge in action in the last couple of weeks. A Cole County judge has tossed an ACLU suit challenging the state's voter ID law. Another failure for that, and people challenging it. The ACLU said the law made it harder for poor people and minorities to cast ballots. A fellow attorney, Denise Lieberman, here in St. Louis, says lawyers will look for other ways to pursue lawsuits against the voter ID law. What could they possibly be? Anybody have any ideas? I mean, this has been the charge case all along, is that it discriminates against poor people and minorities.
Right. Well, this initial challenge has been a challenge to the law as it is written. I think the next level is challenging the law as it's applied. The law provides for provisional ballots, says that you don't necessarily need a photo ID. You can have other forms of identification. And so if there are some people that go to vote and they have what the law says would be good identification, but then poll workers say you can't cast a ballot, there's another challenge, so it'll be a challenge as applied.
Wow, thank you for clarifying that for us, Peter Joy. Let's see, what else have we got here? We've got, Bill, you brought up something this morning I didn't know, and maybe others didn't as well, and that is the trouble that the current acting FBI director, McCabe, is facing now from Donald Trump. This becomes kind of a hometown story in a sense because he's got a St. Louis connection. So
McCabe became the acting director after Comey was fired, and of course now we have a permanent director, Ray. But Donald Trump has really taken after McCabe in his Twitter feeds, and apparently, after Trump fired Comey, he then met with McCabe when McCabe was about to take over to see, sort of as like a job interview, whether or not he would take over as acting director. And he asked McCabe the question of who'd you vote for in the last election, Hillary or me. And McCabe's answer to that apparently was he had not voted. The claim that Trump makes about McCabe is that because McCabe's wife was running for office in Virginia, and because she received financial support from Terry McAuliffe, Hillary Clinton's buddy and former governor of Virginia, that therefore he was biased and he shouldn't have been involved in any of the investigations of the Hillary Clinton server and emails and contributions to the Clinton Foundation. But McCabe had actually was not yet the deputy director at the time. Was not deputy director at the time of the contributions. It was only later, after she had lost, that he was deputy director and was involved in those investigations. But as you say, there's the local connection is that he's a Washington U law graduate. A lot of FBI folks and government integrity folks think it's improper for the president to be asking a civil servant, which is what he was, whom he voted for in the last election. And it's part of this Trump and Republican effort to delegitimize the FBI as sort of the distraction from Mueller's investigation, which proceeds.
Fueled by the Clinton connection to all of this, which apparently is something that the president just can't get beyond, the whole Clinton thing as a result of the election.
It doesn't seem like it.
Yeah. Well,
So McCabe was at the law school in '93. He graduated. I was a brand new dean of students at the law school, so I remember him. And he's our second WashU Law head of the FBI, because William Webster, what was that, in the late 60s, early 70s?
no, later than that.
Was it
Well,
later?
late 70s,
Because he was
early
CIA
80s.
before the FBI.
Right.
No, he was CIA after the
After
FBI.
FBI, okay.
He was FBI director in 1980, I think late 70s and early 80s.
It was under Reagan.
etc.
It was on Reagan, I
It
believe.
was.
Yeah, I guess you're right.
He
Yeah,
was
yeah.
definitely the FBI director while Reagan was president.
So you two gentlemen from Washington University are very, very proud today to have
Yeah.
this
Well,
association.
Well, Bill's a WashU Law
Yeah.
alum, and Peter's, so
We're all proud.
We're all very proud.
Well, I am not, and I'm proud. I'm proud too, by God. Let's take another break, get that out of the way, come back and talk about some other things. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Welcome back as we continue our Legal Roundtable panel discussion with Bill Freivogel, Mark Smith, and Peter Joy, all proud associates of the Washington University School of Law in one way or another. Let's stay with the national picture for a bit. There are a couple of things going on here that we should talk about. Once again, the Supreme Court will rule on the latest iteration of the Trump travel ban. Hear arguments in the spring, and I guess this is going to finally resolve it one way or the other, wouldn't you think, Peter?
Well, it will resolve this particular travel ban. I suspect that if it goes against what Trump wants, that he'll make a new travel ban. So I think he's going to get a travel ban one way or the other.
So reading the tea leaves, because the Supreme Court decided to let the travel ban be enforced while the case is moving forward, that may mean that there's a majority to support the third iteration of the travel ban, which was struck down by the Ninth Circuit Court of Appeals in a Hawaii case, and which is still before the Fourth Circuit Court of Appeals in Maryland. On a religious, whether it violates the Establishment Clause, the religious freedom part of the First Amendment. So the Supreme Court said they would look at that issue too. I guess sort of preparing for that Fourth Circuit case to come to them. So yeah, I think it will resolve it. I think Trump will probably win or mostly win. The case will be argued, I guess, in the spring, decided by July.
Yeah. And part of the reason he'll win is because he's added in the countries of Venezuela and North Korea, which are not predominantly Muslim nations.
And the government also makes the argument, which strengthens their case, that the initial travel ban was based upon questions they had about the vetting process in these countries that were named. Now they say they have done an investigation, and that investigation has found that there are serious issues with the vetting of people coming from those countries. And so the president, in his role as commander-in-chief, has made the decision that the country needs to be protected from them. Now, that's a hard argument. We may not entirely believe it, but that is a hard argument to counter in the Supreme Court.
And what they're going to point to is the things that candidate Trump said that were anti-Muslim, and so I think that becomes not that I'm endorsing what he said, not at all, but I think candidates have a wider range of what they can say and not say, and then the actual office holder restricts themselves. Now, Trump hasn't restricted himself as much, but he has certainly restricted himself more than he did as a candidate, I think.
Peter, has the inclusion of Venezuela and North Korea really marked the only difference between this version that the court will deliberate and the previous two attempts?
Well, I agree with what Bill said. Plus the fact that they claim now that they have looked into the vetting and there's a problem with vetting. I guess the other thing is, although as a candidate Trump said a lot of anti-Muslim things, he's also tweeted some anti-Muslim things as president.
Yeah, right.
So he's not helping the case out very much. But, of course, that seems to be his trademark.
Yeah.
I think also there are some exceptions under this latest ban. So you can still apply for individual exceptions. There's I think for tourism it's different. So it's not as blanket as it was before.
Mm-hmm.
Okay, let's move on to other Supreme Court action, which could be extremely important, I think, and that is the issue of gerrymandering. Mm-hmm. The court temporarily blocked a lower court ruling ordering the North Carolina legislature to come up with a revised congressional district map. The current one favors the Republicans. What does the fact that the Supreme Court moved here tell us about its attitudes?
So this is these are cases that involve political gerrymandering, and we haven't yet had a case where the Supreme Court has said, yes, that is a political gerrymander and it violates the Constitution, either equal protection or the First Amendment. They have a case before them that has been argued from Wisconsin, and that case is pending. So the North Carolina case was the court said this is a political gerrymander. And Rick Hassan, who's an expert on election law, says it's the worst political gerrymander that he has seen. But what the Supreme Court is saying, North Carolina, you don't have to redraw these districts yet. We're going to wait until this appeal gets to us. And by that time, they will have decided the Wisconsin case, and we'll know whether or not the Supreme Court has been able to find a case where there actually is a political gerrymander. The other political gerrymander issue that's really interesting is in Pennsylvania, where a state court ruling on entirely state grounds. I guess I'm not sure we know yet exactly what the state grounds were, but fair and equal election seems to be, that's in their state constitution, seems to be the gist of it. But the Pennsylvania state court has found that congressional gerrymander is a state unconstitutional political gerrymander and is ordering the legislature to immediately redraw the districts for the upcoming election.
By February 9th.
Really fast.
Yeah.
And that also, the Republican legislature has very much gerrymandered those congressional districts. And so a redraw would seem like at least give the Democrats one more and maybe multiple additional ones. Now, the Republicans have said they will appeal to the Supreme Court. There doesn't seem to be a federal question, but, we all have to remember Bush versus Gore. Also, there didn't seem to be exactly a federal question in that one either. But I think it's unlikely the Supreme Court would get involved.
Is there a Maryland case as well that is involved in the gerrymandering?
There is a Maryland case. I think the Supreme Court has already agreed to hear that, and I don't think they've argued it yet, but I'm not 100% sure. The difference between that and the Wisconsin case is I believe the Maryland case is is based on the First Amendment. There's the political gerrymander favoring Democrats. That violates the First Amendment rights of voters. And of course, we have political gerrymanders real close to home, right across the river in Illinois. They've had pretty effective Democratic gerrymanders for a long time.
Where could the Supreme Court take us on the issue of gerrymandering? I mean,
I think
because these are state issues, are they not?
But like Bill said, if it affects my First Amendment right, if I am packed in with a bunch of Democrats, even though that's not the natural thing, it undermines my voice in the process. But part of the challenge the Supreme Court has said, during this case is, well, how do we? There's no bright line rule we can do, so we don't. They don't want a whole bunch of cases coming to them every time a state does redistricting. They don't want it in front of the Supreme Court, and I think that's one of the things they're struggling with. How do we know what is and what isn't, but how do we give an easy to follow rule so we're not cluttered with all these cases, and the federal courts are not cluttered? We don't want that.
And did you want to say something?
No, I just wanted to sort of point out something that Bill said, which is the Pennsylvania case is much different than these others because it was decided solely on state law grounds. And so unless the court says that the state law conflicts with the U.S. Constitution, the Pennsylvania case stands.
The one way in which I think that the people would try to claim it violates the U.S. Constitution is that the Constitution requires legislatures to draw districts, but the Supreme Court has not seemed to be disposed to agree with that in past cases from like Arizona. So I think that will probably go ahead in Pennsylvania and make quite a bit of difference. But I think in North Carolina, the districts will not be redrawn before the next
Wisconsin
election.
cases.
But whatever the Supreme Court does or doesn't do, we are not likely to come up with a system that will apply the same way in all 50 states, will we?
No. I mean, there are some states that have avoided this issue largely with bipartisan commissions that have drawn it up. Right. But I don't see the Supreme Court forcing states to adopt a particular remedy.
But there could be a constitutional rule, just like one man, one vote, one person, one vote, is a constitutional rule that all reapportionment has to comply with. And so, if the Supreme Court says that the Equal Protection Clause of the First Amendment imposes a constitutional rule of no political gerrymanders, and they can describe what, tell courts, rules they can apply to determine when is there a political gerrymander. That could be a constitutional rule that all legislatures have to comply with, although it would still be in their hands to actually set up the process for drawing the districts.
And we talk about these things as we expect everybody to understand what we're talking about. Peter, maybe if I can turn to you to explain what gerrymandering is and how it influences elections.
Okay. Well, gerrymandering in its named after the strange shapes that some districts end up being to try to either pack a lot of one party into one particular district rather than having them spread out, or drawing boundary lines where you're picking up in a district voters of a particular party. So that's why you can look at various state maps and you see very strange shapes because it's almost identifying all the Democratic or all the Republican voters in a district, or it's packing them all in to one district where if they were evenly dispersed, they might comprise 2 or 3 districts. So it's trying to get a political advantage by as I said, either packing the voters in so that they're not getting their fair representation, like maybe in Pennsylvania, or drawing the districts in strange shapes that occurs almost in every state.
It's the packing that, like you said, or cracking, where they get they divide them up, and so you have situations. I think Pennsylvania is like this. It was, basically 50-50 in the presidential election, but the Republicans have like 2/3 of the House. The seats because of the way they've drawn it,
and now because of the computers, lawyers and politicos can very carefully figure out how do we maximize our party's control of state legislative elections, congressional elections. And they can do it effectively. Like in the Wisconsin case before the Supreme Court, I think they showed that Democrats could win 59% of the vote in the election and still not get a majority of the seats.
Mm-hmm. We should point out the advantage is a 10-year advantage because it only happens every 10 years following
and the Supreme
census.
Court has said you can't gerrymander because of race, but you can draw a little finger out of your district because the incumbent lives there and you want to keep them there, and that goes on all the time. So this would be new ground if they come in and say you can't do it for political purposes.
And those states where they are using commissions, it's working out pretty well from what I've read and understood.
I think people would say they're mixed results. Yeah. There are some commissions that work better than others. In some of the states that have had commissions where they have seemed to work, a different political party gets in power and they want to dismantle the commission because they want to get that advantage. So there's some controversy. But
what we need is an app. Something. And I'm saying that as a joke, but not really. We need a computer program that says here are the factors that are important. We want this and this, and take the people out of it.
You sure there's not an app for it already?
There probably is an app, right? Yeah.
I don't know if we want to take the people out of it.
Yeah.
All right, another issue we can get to as time winds down, and that is the issue of juvenile defendants. The Missouri General Assembly is just looking at legislation right now which would increase the age in which juveniles can be tried as adults from 17 to 18. Good idea, Peter? The criminal justice is in your bailiwick?
Yeah, I think it's a very good idea. That's the way it used to be in most jurisdictions before states started lowering the age. You can still have somebody who's younger be certified as an adult. This just says that, in general, 18 is a cutoff point, and I think that's based a lot on what neuroscience tells us about how brains develop. Even there'll be arguments about, well, can we even say between 17 and 18, is there much of a difference? But there is some difference, and I think it's a good move.
The brain not fully developed, not even at 18. It's
That's
a
correct.
few years after that. But there are certain parts of the brain that are definitely not developed, and that can cause some real problems.
So it's the same. That's the same rationale that the Missouri Supreme Court first, and then later the U.S. Supreme Court used to say that we shouldn't have the death penalty for juveniles, and that juveniles should not be people who commit murders, while juveniles shouldn't be able to be sentenced to life in prison without parole.
That's before the Supreme Court.
The Supreme
been
Court
decided.
has ruled both those things.
Yeah. Okay, well, we'll see how that works out. I think this has been in front of the Missouri legislature in the past, and
Right.
just
And we're
is
one
just
of five states that doesn't have this legislation.
Okay, time winding down, and I do want to make some mention of the loss we experienced this month of Frankie Freeman. Thoughts about Frankie Freeman, gentlemen? She was a civil rights icon, needless to say, and very, very influential in civil rights legislation over the years. Bill, I'll start with you.
Well, she certainly was, and she was, I believe she was the first woman to be appointed to the Civil Rights Commission. 1964, she served on that, I think, until 1979, was a very important voice there. I mean, her life shows the difficulties. She graduated from, I think, Hampton Roads and had trouble getting a law school that would accept, the credits. Eventually, she got her law degree from Howard. She won a big housing discrimination case in St. Louis in 1952, saying segregation, this is pre-Brown versus Board of Education, saying that segregation of the housing, public housing, was unconstitutional. She later worked with Chancellor Danforth on the commissions that found a settlement to the St. Louis school desegregation case and continued that desegregation plan into the indefinite future. It is still with us now, even if it's in a smaller version and possibly phasing out in the future. So that was an enormous contribution. I believe also she and Danforth had made the recommendation that temporarily, and I think that time's coming to an end, there be a separate body to run the St. Louis public schools to improve those schools. They've improved, and I think it looks like now they're going to be turned back over. So she's been an enormous and inspirational force in civil rights.
And Mark, another connection to Washington University.
Yeah. And I didn't know her, but I just love those pictures of her and Dr. Danforth together, and they just seem to so genuinely enjoy each other, and just two really nice people doing really important things and making the world a better place. It's just really, it gives you a good feeling when you see that.
And Peter, she died at the age of 101, was as sharp as a tack right up until the end, from what we all understand of her. What are your thoughts about Frankie Freeman?
I just want to echo what's been said. A true inspiration, and I think someone who also inspired quite a number of law students and young lawyers throughout her career to do better and to work for justice.
We have on our website something I would like to point people to, and have done it on occasion. We were talking about Frankie Freeman the other day with some associates over the years, including Percy Green, a longtime civil rights activist. We have a wonderful piece of tape on the website of a conversation between Frankie Freeman and Percy Green talking about the rule of law versus civil disobedience. We know what side Percy was on. He was very influential in the 60s, needless to say, and we know what side she was on as well. And it's I recommend that heartily. Any final thoughts? We have 10 seconds left.
I'm gonna go look at that conversation because I've talked to them both, and I'd love to hear that debate.
Well, there it is. You'll find it at stlpublicradio.org. It's on the homepage there, I believe. Still, if not, go to the St. Louis on the Air tab, if you will. Gentlemen, thank you so much. Bill Freivogel, thank you for being with us. Peter Joy,
thank you.
Great to see you again. Thanks for being with us. And Mark Smith, wonderful to have you with us as well. That's going to do it for today. Archive versions of past St. Louis on the Air programs are available for download or podcast at stlpublicradio.org/STL on Air. St. Louis on the Air is a production of St. Louis Public Radio, 90.7 KWMU. Thank you for listening. I'm Don Marsh.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.